The Supreme Court chamber had fallen into a level of silence usually reserved for the final moments of a historic verdict. Justice Elias Bryer, one of the court's most senior voices, leaned forward slightly in his leather chair. Every set of eyes from the clerks lining the wall to the journalists pressed into the back row shifted toward the podium where Representative Janelle Crocker, only 43 years old and known nationwide for her relentless advocacy, stood with calm confidence. What had begun as a routine argument in a pivotal voting rights dispute was about to turn into a moment the legal world would dissect for decades. Representative Crocker, Justice Bryer said, his tone carrying through the hushed room like a bell. In the many years I have served on this court, I cannot recall hearing an argument delivered with such analytical clarity and constitutional precision. A ripple of shock passed through the chamber. Justices froze mid-note. Senior attorneys exchanged startled looks. Even the public gallery reacted a low wave of murmurs rising before being quickly silenced by security. No one could remember the last time a Supreme Court justice openly praised an advocate in the middle of oral arguments, especially one standing before the court for the first time. Yet the words that Representative Crocker spoke next did something even more remarkable than simply acknowledging the rare compliment. They altered the entire trajectory of the case and left Justice Bryer, a figure famous for his calm intellect and elaborate hypotheticals, momentarily speechless. But before diving into the moment that forever changed the dynamics of the courtroom, make sure you stay with USA. This unfolding legal drama reveals how constitutional battles continue to reshape the nation. A morning of anticipation. The marble corridors of the Supreme Court echoed with anticipation that crisp October morning. Law clerks rushed between chambers carrying towering stacks of briefs. Reporters clustered in small circles whispering predictions about the arguments ahead. Outside, security guided the large crowd of citizens as some activists, some students, some curious observers who hoped to witness the high-stakes showdown on voting rights. The case, Jefferson v. State Election Authority, challenged a controversial state voting law responsible for closing hundreds of polling locations in communities predominantly made up of racial minorities. A lower appellate court that considered one of the most conservative in the country had upheld the law, leaving many experts doubtful about the appeal's chances. What made this case especially unusual was the person who stepped forward to argue it. Representative Janelle Crocker, a civil rights attorney before entering Congress, had personally requested permission to present the oral argument herself. It was an unusual move. Members of Congress rarely argue before the Supreme Court, but Crocker's connection to the case ran deep. Many shuttered polling locations were in the very communities she represented, the communities that had trusted her for years to defend their voting rights. The players enter. On one side of the courtroom sat Justice Elias Bryer, 83 years old, representing the seasoned intellectual tradition of the court. With decades of judicial service, he had built a reputation for measured pragmatism and for posing intricate hypothetical questions that often challenged even the sharpest lawyers. He was known for long, exploratory lines of inquiry, and advocates before him were expected to prepare for anything. Across from him stood Representative Crocker, part of a newer generation of leadership, sharpened by years of courtroom battles and community advocacy. Born in a middle-class family in the Midwest, she worked her way through college and law school, eventually becoming a relentless civil rights attorney focusing on voting rights, police accountability, and criminal justice reform. Her record included multiple major victories and a reputation for extraordinary preparation. What made her especially formidable wasn't just passion, but precision. She approached advocacy like a scientist, layering facts, precedent, statistical evidence, and constitutional doctrine with meticulous care. The stakes. The law at issue claimed to optimize polling locations using neutral-sounding criteria like historical turnout, regional funding levels, and logistical efficiency. In practice, the formula removed more than 300 polling places from communities with large minority populations while leaving affluent districts untouched or even adding new locations. For voters without cars, stable schedules, or access to reliable public transit, the new travel time often 10 to 20 miles each while had made voting nearly impossible. This wasn't just a dispute about logistics, it was a fundamental question about whether modern voting restrictions could disguise discriminatory effects behind layers of bureaucratic terminology. The argument begins. Representative Crocker stepped to the podium wearing a simple navy suit, her notes minimal, her expression focused. She inhaled, prepared herself, and nodded as the Chief Justice opened the session. Representative Crocker, he began, you argue that this statute violates both the Voting Rights Act and the Equal Protection Clause, yet it never mentions race. On its face, it applies the same criteria statewide. How, then, do you establish discriminatory intent? Crocker met his question head-on. Mr. Chief Justice, she said calmly, this court has long recognized that discriminatory intent can be shown through factors beyond explicit language. Under the framework established in this court's precedents, we examine historical context, procedural irregularities, legislative sequence, and disparate impact. She then laid out how each factor was supported by evidence via emails, statistical analyses, legislative history, and testimony so effectively that several justices exchanged subtle glances. Justice Nathaniel Price leaned forward. Representative Crocker, the state insists that budget concerns drove these closures. Isn't that a legitimate interest? Justice Price, she replied instantly, if cost saving had been the actual purpose, polling reductions would be evenly distributed. Instead, over 90% of closures occurred in minority-majority districts, yet they saved less than 1% of the state's election budget. The numbers reveal the motive. Even Price raised an eyebrow, a rare for the reserved justice. Justice Myron Caldwell followed with a question on burden analysis under election law precedent. Crocker responded with confidence, citing real-world data, travel times, transit schedules, and statistical models demonstrating severe burdens imposed on targeted communities. She even used a device to display an actual recorded bus route a voter would have to take now and more than 3 hours each way. Justice Rowland pushed back, but Crocker countered with a comprehensive study in the record showing that over half of affected voters faced similarly unreasonable travel times. For nearly 40 minutes the exchange continued. Crocker answered rapid-fire questions with precision, never losing focus. And then came the moment that shifted everything. Justice Bryer, notably quiet up until now, finally spoke. Representative Crocker, he began, let's consider a hypothetical, a broken bar. The room stiffened. Everyone knew what that meant. Justice Elias Bryer adjusted his glasses, the faintest hint of a smile touching his normally reserved expression. His hypotheticals were the stuff of legend, intricate puzzles designed to test an advocate's grasp of constitutional doctrine under pressure. Lawyers often stumbled. Some panicked. A few froze entirely. So when he leaned forward, the tension in the courtroom sharpened. Representative Crocker, he said, imagine a state implements a voting system based on something seemingly trivial, say, the final digit of a voter's identification number. Those with odd numbers are assigned to one location, those with even numbers to another. Now imagine that, for reasons unrelated to the statute itself, this results in 90% of minority voters being assigned to the farther, more burdensome location. No racial language, no explicit targeting, yet extraordinary disparity. Would that violate the Constitution? The air thickened. Even veteran Supreme Court advocates sometimes struggle with these layered hypotheticals, say equal protection doctrine, discriminatory intent, disparate impact, and structural burdens, all wrapped inside one question. Representative Crocker took a steady breath. For the first time, she paused, not from uncertainty, but out of respect for the complexity of the scenario. Justice Bryer, she began, her tone as deliberate as her words, your hypothetical presents a rule that appears neutral but produces severe racial disparities. This court has long recognized that facial neutrality does not absolve discriminatory outcomes, especially when the design or application of a rule aligns suspiciously with racial patterns. Several justices leaned in. She continued, the deeper issue in your hypothetical and in this case is whether policymakers create or select these neutral criteria because they achieve certain demographic results. Then she made a pivot that shifted the room's energy. And that is exactly what we see in the law before us, she said firmly. The state chose metrics that were statistically correlated with race, not by coincidence, but by deliberate design. Justice Bryer, visibly impressed, pushed his analysis further. But, Representative Crocker, he said, some might argue that extreme cases make easy law. What about less obvious circumstances? How do courts distinguish neutral governance from disguised discrimination? Crocker didn't miss a beat. By examining pretext, she answered, and by scrutinizing the sequence of events behind the law. Here, we have messages, internal communications, and procedural irregularities that show the legislature wasn't merely indifferent to the racial impact, that they were aware of it, discussed it, and then crafted criteria to mask it. She lifted a single sheet of paper from her binder. This document, she said, is a statistical analysis performed by the state's own technical staff before the law was passed. Their formula correlates at over 90% with racial demographics. That means the so-called neutral criteria were functionally indistinguishable from using race outright. The audience reacted audibly to an unusual breach of protocol. Justice Bryer clasped his hands, nodding slowly. It wasn't approval, it was recognition. He had seen every kind of advocate over decades, but the precision of Crocker's argument was severely disciplined, strategic, exhaustive. But he continued pressing. Correlation, yes, Representative, he said, but what about causation? What proof shows that lawmakers knew this outcome and proceeded anyway? Crocker didn't look down at her notes. She didn't have to. We have 3 categories of evidence, she said. She held up one finger. First, statements made during the legislative process dismissing concerns about minority voters and implying that obstacles are the voters' responsibility, not the state's. A second finger. Second, internal political calculations, and not about race explicitly, but about how reducing turnout in specific areas would shift electoral outcomes. While they frame it as partisan, they acknowledge those areas are overwhelmingly minority. A third finger. And third, testimony from a legislative aide who witnessed closed-door conversations where lawmakers discussed crafting a neutral criteria that would shrink turnout in minority districts while avoiding explicit racial language. She lowered her hand, her voice unwavering. Taken together, these are not coincidences. They reveal deliberate engineering. At the council table, the state's Solicitor General stiffened. His hand twitched as though he might object, despite the fact that objections are not recognized in the Supreme Court. The Chief Justice cast him a warning glance. Justice Bryer sat back, studying Crocker for a long moment. "Thank you, Representative," he said quietly. It wasn't just acknowledgement, it was an admission that her argument had struck at the heart of the constitutional question. The state responds and struggles. When Representative Crocker finally stepped back, the courtroom felt different, charged, unsettled, expectant. The state's Solicitor General rose, trying to project calm, but his uneasy grip on the podium betrayed him. Chief Justice Aldrin, normally soft-spoken, began with an unusually direct question. "Counsel, let's address the internal communications. Are you disputing their authenticity?" The Solicitor General swallowed hard. "Your Honor, those messages pertain only to partisan considerations, which this court has previously acknowledged as permissible." Justice Dana Marwood, one of the court's sharpest interrogators, cut in immediately. "But counsel, the communications explicitly refer to the racial composition of the communities impacted. They are discussing the effect on voters who are overwhelmingly minority. How do you reconcile that with your claim of neutrality?" The Solicitor General faltered. "Justice Marwood, the context of if I may." Marwood held up the document. "There is no additional context provided. The message reads plainly." The courtroom sensed the unraveling. Justice Rowland spoke next, his tone sharper than usual. "Counsel, how do you address the testimony from the legislative aide?" The district court found it credible. The appellate court dismissed it without explanation. "Why?" Justice Rowland, "We believe the testimony was unreliable." "Based on what evidence?" Rowland interrupted. The Solicitor General hesitated, searching for a foothold he didn't have. Justice Bryer delivered the final blow. "Counsel," he asked calmly, "is it your position that a law creating severe, predictable barriers for minority citizens is constitutional so long as its language is neutral even when lawmakers knew and intended those consequences?" The Solicitor General's pause was devastating. Justice Bryer, broken bar. Our position is that only explicit racial language or undeniable evidence of racial intent should trigger constitutional concern. So indirect discrimination is acceptable? Bryer asked, voice steady. No, Your Honor. That's not what the justice's raised eyebrow said everything. The Solicitor General's time expired with the courtroom still buzzing from the exchange. Crocker's rebuttal. The Chief Justice turned to the petitioner's table. Representative Crocker, you have 4 minutes for rebuttal. She rose, walked to the podium, and spoke with quiet force. Thank you, Mr. Chief Justice. I will be brief. Her tone shifted to less technical, more foundational. Our Constitution does not allow sophisticated discrimination to succeed merely because its architects know how to hide it behind statistics and bureaucratic language. Several justices nodded subtly. The evidence demonstrates intentional suppression of specific communities under the guise of efficiency. That is precisely the type of harm the Reconstruction Amendments and later civil rights protections were designed to prevent. Her voice grew softer. This is not about convenience. This is about citizens being effectively silenced. And when that happens, our entire democratic framework weakens. She paused. The Constitution entrusts this court with guarding those fundamental rights. We ask that you fulfill that duty. She stepped away from the podium. Even her critics appeared moved. Chief Justice Aldrin nodded. The case is submitted. The doors of the Supreme Court closed behind Representative Janelle Crocker with a heavy, echoing thud. For the first time in months, she exhaled without the weight of preparing for the next brief, the next filing, the next defense of the voters who had been silenced. But the battle wasn't over. Now came the waiting. Crocker stepped onto the plaza, the sun washing over her in sharp winter light. Reporters were already positioned behind the rope line, microphones angled toward her like a forest of antennas sensing a storm. As she descended the marble steps, murmurs rippled through the crowd. Some recognized her from the arguments, others recognized the significance of the case. A security officer nodded her forward. She approached the podium. Hundreds of eyes waited. Representative Crocker looked steady, but beneath the poise was a mind replaying every question, every answer, every raised eyebrow from the justices that hinted at how they might decide. She began. The press scrum. Representative Crocker, a reporter called out immediately. How do you think the hearing went today? She offered a calm, diplomatic smile. I think the court asked serious, substantive questions. That's all any advocate can ask for. Another reporter jumped in. Justice Bryer pressed the state's lawyer extremely hard. Did you interpret that as a sign of where he might vote? Crocker shook her head. The justices probe weaknesses on all sides. That's not a prediction, it's their job. A third reporter, more blunt, asked. If the court rules against you, what does that mean for minority voters across the country? The question hit like a stone thrown into still water. Crocker paused long enough for the silence to gain weight. It means those voters, she said carefully, will face barriers that are invisible on paper but very real in practice. And it means state legislatures will feel free to design systems that appear neutral but function as tools of exclusion. Her tone remained professional, but her eyes conveyed something deeper. This was personal. Someone else shouted over the crowd, do you believe lawmakers acted with discriminatory intent? She didn't flinch. Yes, she replied, because the evidence shows they selected criteria after analyzing how those criteria would suppress turnout in certain communities. That's intent disguised as administration. The murmurs intensified. Camera shutters clicked like snapping twigs. Before another question could be thrown, her aide, a young staffer with a trembling notepad, leaned in and whispered that they needed to move. Crocker stepped away from the microphones and into the waiting vehicle. Behind closed doors at the justices' conference, inside the marble fortress, long after the public left, the 9 justices gathered around a polished oval table for their private conference, a place no cameras, clerks, or transcripts were ever allowed. Chief Justice Aldrin opened the meeting. Colleagues, we have before us a question that goes to the core of equal participation in democratic life. He turned to Justice Bryer. Elias, your vote? Justice Bryer laced his fingers together. This law, he said, is a masterclass in how discrimination evolves. It's no longer blunt exclusion, it's mathematical exclusion. The record shows clear awareness, deliberation, and intent. I vote to strike it down. Justice Marwood followed, agreed. The state engineered correlation to racial patterns and then hid behind neutrality. That is the sort of sophistication the 14th Amendment must be prepared to confront. Justice Rowland leaned back. The appellate court's dismissal of the testimony was indefensible. When we allow legislatures to manipulate turnout with impunity, the Constitution becomes ornamental instead of operative. I vote with the petitioners. But not all were convinced. Justice Hargreave cleared his throat. This court must not become a political referee, he said. If legislators choose poorly crafted criteria but avoid explicit discrimination, our role is limited. I vote to uphold the law. Justice Alcott nodded in agreement. Intent must be unmistakable. Otherwise, we invite every voting rule in the nation to be litigated based on statistical disparity alone. 3-2 so far. The remaining justices would determine everything. Justice Lantona, known for her deliberate methodical thinking, spoke next. This case troubles me. The state's explanations feel pretextual, but I'm wary of expanding doctrine in a way that oversteps judicial bounds. A broken bar need more time. Justice Pierce, usually quiet, added, I share Justice Lanton's concerns, but the state's lack of candor today was alarming. That weighs heavily. The Chief Justice looked around the table. We will circulate draft opinions, he concluded. The nation will expect clarity. The wait. In her small office back at the Capitol Annex, Crocker sat alone. She had removed her blazer, her shoulders tense from months of carrying the case. A stack of documents still sat on her desk, not because she needed them anymore, but because she couldn't bring herself to file them away until the decision came. Her phone buzzed. A message from her father. Proud of you. No matter the outcome. She closed her eyes. For a moment, she wasn't a litigator, or a legislator, or the face of a national court battle. She was simply someone who had fought for people whose voices had been brushed aside. Tomorrow would bring commentary, political spin, and pundit debates. But tonight, she allowed herself a moment of stillness. Outside her window, the city lights flickered like distant stars. Somewhere beyond them, 9 justices were drafting the words that could reshape the electoral landscape of an entire nation. She whispered to no one, please let them get this right. The nation held its breath. News channels replayed the oral argument on a loop. Analysts debated every eyebrow raise, every pivot, every pointed question from the justices. Commentators claimed the court was divided. Others insisted the questioning signaled a sweeping decision. But no one truly knew. Representative Janelle Crocker did not watch any of it. Her days were filled with legislative work, but her thoughts were never far from the marble building across town. Every time her phone buzzed, she wondered if a clerk was notifying her counsel team that the decision had been released early. It hadn't. Not yet. Late in the evening, she returned to her office, dim except for the glow of a desk lamp, files lay open but ignored. Her laptop screen showed an unfinished email she had typed and erased 3 times. A knock came at the door. Her aide stepped in, holding a folder. Congresswoman on a broken bar. It's the projected release calendar. Crocker exhaled through her nose. Steady, controlled. Put it on the desk. The aide hesitated. You know, whatever happens. I know, she said gently. Thank you. The aide nodded and closed the door. Crocker stared at the empty room. The silence reminded her how much was at stake. Families she'd met in community centers, college students who waited hours at understaffed polling locations, elderly voters whose precincts had been quietly moved miles away. They were waiting, too, inside the court. A draft opinions. While the world waited, the 9 justices were already neck-deep in negotiation. Justice Breyer's chambers buzzed with controlled urgency. Clerks moved between stacks of law review articles, demographic data, and past precedent. On the center table lay the first draft of his majority opinion at 29 pages of precise reasoning. He read the opening paragraph out loud. A law does not escape constitutional scrutiny simply because discrimination is performed with algorithms instead of blunt language. He marked the margin with a pen. Stronger, he murmured. A clerk approached. Justice Lanton's chambers requested a revised section on historical context. She's leaning your way, but wants assurances we're not expanding the doctrine beyond necessity. Bryer nodded knowingly. Justice Lanton was the fulcrum. A cautious, doctrinally conservative, but deeply principled. Prepare an alternative draft, he instructed. We must show her the narrowest path that still preserves the heart of this decision. Down the hall, Justice Hargreave reviewed his dissent. His clerks stood silently as he struck through a paragraph with an irritated scrawl. This isn't about endorsing bad laws, he said. It's about preventing courts from governing elections. A clerk cautiously offered, but the Ricarda. Hargreave cut him off. Intent must be explicit, otherwise we undermine legislative authority. Meanwhile, Justice Piercia, often quiet, rarely the swing vote, outpaced his chambers, rereading sections of both drafts. The weight of the middle position fell squarely on him. This case, he said softly, will define how subtle discrimination is addressed for the next generation. His clerk responded, Justice, the evidence shows they designed the criteria with expected outcomes. Yes, Pierce replied, but we must decide how much that matters under the Constitution. He stopped pacing. And whether we allow laws that hide the true purpose behind data models. The signal. 3 days later, at sunrise, Representative Crocker's phone buzzed. A message from her appellate counsel. Decision is coming today. Her breath caught. She dressed quickly in navy suit, hair pinned back, her notes ready even though she wouldn't be speaking. Her driver navigated through morning traffic toward the Supreme Court. Activists, reporters, and curious onlookers were already gathering outside. Some held signs of hope, some signs of frustration, all signs of tension. Crocker remained in the front row of the courtroom as the justices filed in. The chamber felt electric, as if charged by thousands of silent voices waiting to be heard. Chief Justice Aldrin opened the session. We have opinions to announce. He shuffled the stack of documents. Crocker's pulse thudded. Justice Bryer stood. The courtroom froze. The reading of the opinion. Today, Bryer began. The court addresses whether a state may construct electoral regulations using criteria chosen because they produce predictable racial disparity while claiming neutrality in language alone. His tone was calm, but the gravity behind it was unmistakable. After reviewing the full record, this court concludes that the Constitution prohibits such measures. A wave of murmurs swelled across the room. Bryer continued, government may not design voting rules that disproportionately burden a racial group where the evidence demonstrates those burdens were both foreseen and intended. Crocker closed her eyes for a brief second, but Bryer wasn't finished. Although the statute appears facially neutral, internal communications, statistical modeling, and procedural irregularities reveal deliberate selection of criteria aligned with racial demographics. This court cannot permit discrimination disguised through methodology. Reporters scribble furiously. Attorneys lean forward. Bryer turned a page. The judgment of the appellate court is reversed. A sharp, audible exhale escaped from the gallery. The aftermath. Outside on the steps, cheers erupted. News cameras pivoted toward Representative Crocker as she emerged. Flash bulbs burst like fireworks. A reporter shouted, Congresswoman, you won. Crocker didn't smile. Not yet. Instead, she spoke with quiet resolve. Today's decision is not a victory for me, she said. It's a victory for every citizen whose voice was pushed aside by design. And it is a reminder that democracy requires constant vigilance. Another reporter asked, do you feel vindicated? She paused. I feel relieved that the court saw through the disguise. But the fight for equal access to the ballot isn't over. It never is. She turned toward the crowd of supporters, students, seniors, community leaders, and finally allowed herself a small, grateful smile. For the first time in months, hope outweighed fear. And somewhere inside the Supreme Court, the paper copy of Crocker v. Wallace slipped into the nation's constitutional historia, ensuring that data manipulation could never again serve as a cloak for discrimination. The court's shadows. Winter deepened over Washington as the Supreme Court continued deliberating. Outside, the city moved with its ordinary rhythm, oblivious to the monumental decision brewing behind chamber doors. Inside the fortress of marble and silence, the justices exchanged drafts, footnotes, counter-footnotes, and polite but cutting disagreements. By mid-January, tensions had begun to rise. Justice Lanton, still undecided, had circulated 3 separate memos, each leaning in a different direction. Her clerks whispered among themselves that she'd rewritten her vote twice already and might rewrite it again. Justice Pierce, though leaning toward the petitioners, continued to probe every angle. He had a reputation for writing opinions that could take months to finalize, and not out of ego, but out of meticulous care for the constitutional architecture. In the Chief Justice's office, stacks of draft opinions grew into a forest of legal reasoning. Some branches clashed, some intertwined, and some refused to bend. Chief Justice Aldrin knew he was balancing more than doctrine. He was balancing the integrity of the court. Crocker's hometown. While the legal storm brewed in D.C., Representative Crocker returned briefly to her district, a place she hadn't seen in months except through car windows and late-night campaign office calls. The town welcomed her like a returning soldier. She visited the small neighborhood community center, where volunteers had worked tirelessly to help voters navigate the complicated requirements imposed by the state's new law. As she walked through the front hall, a group of elderly